Hi friends. After covering the topic of vicarious liability in our previous lecture, now we are here today to discuss about the doctrine of sovereign immunity. So this is the 12th session of the Law of Torts class, and today I am Lokesh Pathak with you, and we will discuss about the doctrine of sovereign immunity. So let's see first what is doctrine of sovereign immunity. Sovereign immunity, it is government's immunity from being sued in its own courts without its consent. So there are three important points in the definition of this. That first of all, it is whose immunity? It is government's immunity. From what? From being sued in its own courts. Own courts is important. And third, without its consent. So it provides government a liberty from getting sued in its own courts, the courts within the country of India, without its consent. The principle behind this immunity is rex non potest peccare, which is a Latin word, Latin phrase basically. I'm repeating it, rex non potest peccare, which means in English that the king can do no wrong. King can never be wrong. So that is the principle behind this. So government is considered as a king in the democracy, and that is why it is given that they cannot do anything wrong. So now what is a reference from the statutes in India about the doctrine of sovereign immunity? The Code of Civil Procedure of India, it provides that the foreign states and their organs can be sued with prior written consent of Government of India. So this immunity is only provided to Government of India, and as per Code of Civil Procedures of India, the foreign states can be sued, but for that we need to take a prior written consent from Government of India. Now let's see one case related to the doctrine of sovereign immunity. That is Ethiopian Airlines versus Ganesh Narayan Sahu. In that case, SC held that doctrine of sovereign immunity in India is not absolute, but it's relative. And the further it was held that the foreign states don't have immunity from judicial proceedings in India which involve either their commercial or trading activities or any contractual obligation which they need to discharge, which they have undertaken in India. So if any foreign state or any of their organ, they have undertaken any commercial or trading activity in India, or if they have to discharge their contractual obligation with any of the entity in India, they cannot be provided the sovereign immunity. So that was the finding of this case. I think this is sufficient for this topic. And now you know the meaning, you know the principle, the Latin maxim behind it, and also what our statute says. And I just represented one case related to that. That is a very small topic, but an important topic. So I would like to close this with this. And in the next session, in the tort, actually the next topic is not related to tort, the 13th class. In that we will discuss about the Consumer Protection Act, which is a separate act, but I will try to cover that in this session itself. Thank you.